Alright, so here we are with the last case for the Module 1 case study. This is Morse v. Frederick. This is going to be about, well, that banner you see on the screen right there. Long hits for Jesus. Alright, so let's jump right into it. First, the focus questions. Is free speech different for public schools than it is for the general population? Do school officials have the right or the ethical obligation to restrict First Amendment rights? And again, how have these courts shaped the issue of student speech over time? Make sure to use multiple cases whenever you're answering this question. So, the student named Joseph Frederick, he was suspended from school, I believe it was for 10 days, for holding up a banner that read the message, "Bong hits for Jesus." I mean, everyone knows that probably shouldn't promote this stuff at school, but I guess that's the generation I came from. When I was in school, there was no legal marijuana, but it's different these days, I guess. I don't know. Kind of brings us back to the last question from the last case study, or the last court case about perception and what should be considered, inappropriate, depending on the generation you're talking about. But anyway, back on topic. The school had traveled to another state to view the Olympic torch runner. So this wasn't happening on school grounds. This was at a school-sponsored event, though. However, Joseph was 18 years old, and he didn't go to school that day. He actually skipped school, and he never went in, and he actually drove down to the event himself. But he did meet up with his friends who were with the school, and he had brought a banner with him. And him and all his friends held up this banner that said, "Long hits for Jesus." He wanted to get on the news. He waited for the cameras to roll by, and he wanted to get on the nightly news, holding up the sign. And when the principal came by and told them all to drop the banner, everyone did, except for Joseph. So he was suspended for 10 days. So what happened next? All right. So the school district was basically sued by Joseph and Joseph's family. So the school district, or the district court sided with the school district and said that the principal had qualified immunity. Now, what is qualified immunity? Well, qualified immunity is a legal term that basically protects any kind of government official from being liable in a lawsuit for damages. So if Frederick were to sue the school for damages, he could also sue the principal, because the principal is the one that took the banner down, or told him to take the banner down and suspended him from school. So qualified immunity protects the actual principal from being sued for damages because she's following the policies of the school, right? So, or the school district. Now, however, the U.S. Court of Appeals for the Ninth Circuit actually reversed the decision, and on top of that, took away qualified immunity from the principal. So that's a pretty big deal. So, what is the problem here? Well, what's the issue? Basically, there's two essential questions to this case. Does the First Amendment allow public students to, public schools to prohibit students from displaying messages promoting illegal drugs? Okay. And then the final question is, when following school policies, does a school official have qualified immunity from a lawsuit? Now, the majority opinion was written by our Chief Justice, John Roberts. He's still currently our Chief Justice today. This was a 5-4 majority decision. Now, there was a lot of concurring opinions. There was a lot of dissenting opinions. There were some concurring and dissenting opinions. We'll get into that later. But anyway, Chief Justice John Roberts wrote the majority opinion. He basically stated that the students they do have a right to voice their political opinions. However, that did not mean that they had the right to undermine the school's mission to discourage drug use. So therefore, the banner was not protected under their First Amendment. Now, the concurring opinion, or there was two of them actually, but the first one was written by the man you see here on the screen, Justice Clarence Thomas. See, Clarence Thomas is one of the older gentlemen on the bench right now, and he's from a different time. He didn't think that students should have free speech. He actually wants to see the Tinker case completely overturned. Uh, he grew up in a different era where you didn't mess around at school. He had a very strict father who grew up during Jim Crow, and when was given the equal rights to go to good schools, well, you did it and you didn't mess around. So that's kind of where he's coming from, and he thinks that students shouldn't have any leniency when it came to speech. They shouldn't be treated the same as adults. Now, Justice Alito stressed that he just felt that way when it came to drugs. When it came to the issue of drugs, students did not have, were not protected by the First Amendment when it came to pro-drug messages. However, anything else, any other political messages would be protected. Now, the dissenting opinion was written by Justice Stevens. This was also backed up by 3 others that basically said, they agreed that the principal should have immunity. However, they felt that the students should be able to voice their opinions, whether the issue has to do with drugs or political messages. Doesn't matter. As long as it's not disrupting the school environment and the learning environment, the students should be able to voice their opinions. Now, here's something to think about. Should the principal have had qualified immunity? And should the principal be able to be sued? Should the topic of drugs fall under political speech? Should, legalizing marijuana be seen as something of a political message, similar to that of the Vietnam War during the Tinker test, or during the Tinker case? Should that fall under the Tinker test? As long as you're not disrupting school, should students be able to promote drugs? And how will this case be used in future cases of student speech? Think about the majority opinion and what kind of precedent it set when it came to student speech. Anything that involved the use of drugs was completely shot down. So this will definitely impact student speech over time. So again, let's pay attention to the focus questions. Is free speech different for public school students than for the general population? School officials have the right or ethical obligation to restrict First Amendment rights for students. Make sure to explain your responses in here, okay? And again, how have the courts shaped the issue of student speech over time? Look all the way back to the first video when we talked about Tinker versus Lemoyne, and so on and so forth, and see how the restrictions on student speech has increased over time, and provide some examples from these court cases to support your answer. Okay?